Here's a question we get probably once a week. So imagine that you're a French national and you want to incorporate a space company in the United States, possibly because you think you'll have greater access to capital here. And you want to know what concerns you should have about your foreign nationality when it comes to US regulation of the space industry. There are 5 issues that come to mind immediately. And the first issue is probably the most obvious, which is the immigration issue. If you're going to relocate to the United States, you'll need to get immigration figured out. Ideally, you'll want to go for a green card or for US citizenship, which will help immensely with the next couple of issues. There's a great book on Amazon called Immigration for Startups, which I can highly recommend. And it was authored by a law firm that we're friendly with called Siskind and Susser. You can find their contact info at visalaw.com. The second issue you'll need to contend with is export controls. If you're operating a company involved in the space industry, then you're probably dealing with technology that is controlled by either the ITAR or the EAR. If a US company shares this controlled information with a foreign person, then that sharing is considered to be an export of such information, which could require a license from the State Department or the Commerce Department. And this is true regardless of whether the sharing occurs entirely within the United States or the information actually crosses a physical border. Now you're probably saying to yourself, Jack, if I've developed the technology outside of the United States and I bring it into the US, then surely the US government doesn't have jurisdiction over that technology. So there can't be any licensing requirement for my own company to share my own technology with me. And as crazy as that sounds, your position would be incorrect. As soon as the technology enters the United States, the US government can claim jurisdiction over it and often does. If your technology is listed on the US munitions list or the Commerce Control List, your company may be required to have a license before you can have access to your own company's files, despite the fact that you developed the technology yourself. Now, it's quite possible that there is a licensing exception that you can take advantage of, but this isn't always the case, and you'll need to conduct an analysis. Of course, if you're considered a US person rather than a foreign person, you won't need to worry about this. And you'll be considered a US person if you are a US citizen or US national, you have permanent legal residence in the United States, in other words, you're a green card holder, or you've been admitted to the United States as a refugee or an asylee. But if you don't fit into one of those categories, then you're considered a foreign person for export control purposes, and that's going to complicate things. The third issue that you'll run into is CFIUS. CFIUS is the Committee on Foreign Investments in the United States. In short, they review foreign investments in US companies, particularly companies that deal in critical technologies, which a lot of space companies are involved in. And they review these investments to determine whether there are any national security concerns. So if you're a foreign person and you are truly a co-founder or a founder of a US company dealing in critical technologies, then you probably don't have to worry about CFIUS because your investment would be considered a greenfield investment, which falls outside of jurisdiction. But if you purchased your shares in the US entity after other folks who considered themselves founders, and perhaps after some of the technology has been developed, certain other factors apply, then you will need to take a hard look at the CFIUS regulations to determine whether you need to give notice to CFIUS regarding your investment. The fourth issue that you'll run into is government contracting. If you're going after, for example, SBIR or STTR opportunities, your company will need to be more than 50% US owned. And if you're going after classified contracts, you'll have to put a lot of procedures in place to mitigate FOCI, which stands for Foreign Ownership, Control, and Influence. Finally, the fifth issue comes when you try to launch something into space. The FAA does a national security review of every rocket and every payload that goes into space under its jurisdiction. As part of this national security review, the FAA brings in folks from several other departments, including the DoD and the State Department, to determine whether they have any issues with the foreign owners of the rocket or the payload under review. Twice in recent history, the FAA has refused to grant a launch license because someone in one of these reviews thought that foreign ownership posed a national security problem. Okay, so that's it. If you have any questions about this topic, please reach out to us at hello@aegis.law and mention that you saw this video. Thanks.